Hi, I'm attorney Gregory Dell with the law firm of attorneys Dell and Schaefer. One of the most technical issues in any long-term disability insurance denial lawsuit is how much time is there before a claimant must file their lawsuit, otherwise their claim for benefits would be denied forever. This is also what's known as the Statute of Limitations. Now, in many long-term disability insurance policies, whether it's an individual disability policy or an ERISA group-governed disability policy, there's often language in a policy that will provide a statute of limitations. And very often that period of time is going to be either 3 years or 4 years from the date of denial in which a lawsuit must be filed. But it's not always exactly clear what is that date of denial and when does this time period start to run from when the claim was actually denied until the lawsuit must be filed. In a recent case that took place in the Eastern District of Pennsylvania in federal court against Hartford, Hartford tried to argue that a person waited too long to file their lawsuit and therefore their claim should be barred. And the facts of this case were very specific, but at the end of the day what happened was that Hartford initially sent a letter saying, "We think that your benefits should not be paid," and they stopped paying the claim. However, within a couple months later, they said, "We're continuing to investigate your claim and we're waiting to speak with some other medical doctors." About 3 months after they sent the initial letter saying, "We're not going to pay you anymore," they finally sent a letter saying, "We've spoken to the doctors and we still are not going to pay you." So you had this 3-month gap. Well, in this particular case, the person waited 3 years from the last letter that was received from Hartford to file their lawsuit. And as a result of that, Hartford tried to argue that you should have filed it 3 years from the first time we told you your benefits were denied. Well, what the court ended up saying in this case was, look, we don't think that first letter was a final denial. We think that the second letter you sent was a final denial because of the fact that you were continuing to investigate the claim. And as a result of that, we're going to allow the lawsuit to go forward. Now, this was a good victory for the claimant and it kept their claim alive. Unfortunately, this was a case that the claimant ended up losing regardless after the case went through the court anyhow. But the message and the lesson you need to learn from this case is if your claim's been denied and you've gone through the appeal process, or even if you don't have an appeal process, you need to take immediate action. You can't wait months or years to file a lawsuit because your claim could be time barred. So if you have a lawsuit, if your benefits have been denied and you're contemplating a lawsuit, you need to contact any of our attorneys as soon as possible. We will review your claim within a matter of a couple minutes and let you know right away whether or not we think we could assist you with your claim. We always offer a free consultation and we look forward to the opportunity to speak with you.